Thank you so much, everyone, for coming to my short, it will be short, a 30-minute masterclass on demystifying debt recovery. I will be taking some questions, but if we can have them right at the end. I'm just going to talk through the process with you, so hopefully you're going to learn something today. A little bit about me. I'm a debt recovery trainer, a teacher to businesses on helping them implement an effective debt recovery process in managing any unpaid invoices and late payments. I'm also a litigation solicitor. I've been doing that for over 16 years. I qualified in 2008 and dealt with contested debt recovery cases throughout the 16 years. Alongside that, I chair the central region of the Civil Court Users Association, which is an organisation lobbying for an efficient, effective and proportionate court service. Members are law firms, in-house legal counsel for banks and building societies, in-house legal counsel for businesses and the enforcement industry. I'm also a member of the Chartered Institute of Credit Management, supporting credit managers, credit professionals in the debt recovery process. And I mentor students at the Royal Holloway University of London, the Advice Centre. It's a free service that they offer to individuals that come for legal help and advice, and I specialise in the debt recovery side and support them on that training. So I don't know how much you guys already know about debt recovery, or if you've ever had to deal with any bad payers in your businesses or organisations, but debt recovery is the process of collecting overdue invoices and overdue payments from businesses or individuals, because sometimes people deal with consumers. I deal with business-to-business debt, and that includes sole traders. That's in a snapshot, that's what it is. But the process can be quite complex if you're not familiar with it, if you're not used to it, and if you don't have one. Then some of the terminology that's used in the debt recovery industry by solicitors can be a little bit daunting. So I'm going to just talk about the 4 key processes from when you've exhausted your internal credit control process, if you've got that, so managing your invoices, chasing your late payments, and you've exhausted that and you're thinking, well, what's the next stage? The next stage is the debt recovery process, and we start off by what the courts will ask you to do is to follow pre-action conduct. It's a formal process where you must notify the customer that hasn't paid you what the debt is in relation to. You've got to provide copies of the invoices, and you've got to give them a time scale, which is usually 14 days within which to respond. And that is a requirement of the rules. If you don't follow that requirement, then there are cost consequences. So it's really, really, really important for businesses to understand that actually we've got to follow the correct rules and processes, because customers and businesses, some of them are quite savvy and they'll be alive to some of the debt recovery processes and will ignore the correspondence if it's not correctly completed. I often get businesses saying, but we've already written to them, we've already told them, we've already notified them, how many more times do we have to tell them to pay up? Why do we have to follow pre-action conduct? Why do we have to send them another letter giving them an additional 14 days? They're already 120 days overdue, so the business is already tearing their hair out, but it's a requirement of the rules. And if businesses don't want to follow that requirement, then that's entirely up to them. But I always advise all the businesses that I work with and clients that I work with, that is a fundamental step in the recovery of the debt, because a letter from a solicitor or an outsourced legal provider does hold some weight and will actually lead to, it won't lead to payment necessarily, but it will engage in some sort of response from the customer that hasn't paid. So it's a requirement. Something that came into place recently that's been made compulsory is also offering the non-paying customer, your debtor, an opportunity to mediate. You have to offer mediation. And parties often feel, well, why should I offer mediation? The debt's owed in full, but you have to be shown willing. That's something the courts will look at when looking at the process further down the line, which is the court stage. So that's your first step. Your first step is to make sure that you've complied with the pre-action conduct for debt recovery in accordance with the civil procedure rules. And those sorts of terminology, if you don't understand, that's where working with a specialist provider of legal services and debt recovery services is essential. I would say make sure that you do understand. I get clients coming to me having done half of the process, they get stuck, they haven't done it properly and they have to start all over again, and that's wasted a lot of their time already. But if you've got the process in place in the first place, you can save yourself a lot of time, a lot of hassle and a lot of money, because again, going to a solicitor, having to fix the mistakes is costly. So avoid those in the first place. The second stage is once you've issued your letter before action and your pre-action protocol letter, and there hasn't been any response, or the debtor just refuses to engage with you and says, take me to court, I don't care. And I say to clients, they're allowed to have the day in court, and if that's their attitude, then that is your next stage, that is the next step. We've tried everything possible. We've given them the opportunity is to issue the county court claim. It's a court form that you can complete online now. So the online civil money claims process, you can submit it online, pay a court fee, and it will issue a claim to the debtor. It used to be called a summons once upon a time, and some people still use the old terminology, but it's called a claim form. Now, it's really, really, really important to make sure your claim form is completed correctly. The details that go on the claim form, your company name, the debtor company name, it has to be done accurately, because if there is any mistake in that, again, it can be costly, it can get thrown out by the court. The debtor may ignore it. At that stage, they become a defendant. They will ignore it and say, well, that's not me. And again, it's a waste of the time of the business, and making sure the detail on that form is crucial. The other thing about the county court claim form is making sure you put everything you're entitled to recover on there. So businesses won't always know that they're entitled to recover late payment compensation for late payments, entitled to recover under the rules reasonable debt recovery costs. So even if you're doing your debt recovery internally and in-house, you can actually claim a reasonable amount. Now the rules don't define what that amount is, but they do say you can claim a reasonable amount. Sometimes it can be anywhere between sort of 2% or 10% of the total value of the debt. And you can claim that under the late payment compensation regulations. And interest on top of that. So late payment interest, late payment compensation, and reasonable debt recovery costs, these are all recoverable under the rules, under legislation, and companies don't always know that. And actually, it's an incentive sometimes for businesses to add all those costs on as a negotiation tool for settlement. It encourages the debtors to say, well, actually, we'll pay the principal debt amount if you waive the interest. And businesses often will say, yes, actually, do you know what, this has been outstanding for so long, I'd rather have the principal debt and move on from this. So that's your claim form. With the county court proceedings, there's a time scale for which the debtor has to respond. They get 14 days. If they don't respond to that claim and they totally ignore it, you can then proceed to the next stage, which is the third stage, which is your county court judgment. So that's a piece of paper, and it is a piece of paper, but it can have adverse impact on the business that we've issued the claim form against, on their credit rating. And some businesses don't care. They're totally not bothered by the number of CCJs they've got. Others phone you up straight away and say, my bank, my lender has said I've got a CCJ. Why have I got this CCJ? And it's because they've ignored all the correspondence. And if you look back at the correspondence, it's all been sent to the same address. Generally, if the person that's completed the paperwork has done it correctly, and they have very little room to argue it, and they will say, okay, fine, we'll pay it as long as you remove it. Now, with the CCJ, you have 30 days within which to pay. Once it gets paid within 30 days, it can get cancelled from the credit rating. If after the 30 days it still hasn't been paid and they've left it a little bit longer, then that CCJ will stay on the credit Yeah, there are ways around it and having it removed, but that goes into more technical aspects of applications that solicitors can make, and that's something that I cover in my one-day Essentials to Proactive Debt Recovery training course. It's something that I offer businesses. It's a lot more deeper, and it works with the business in setting up the process. Once the county court judgment has been issued by the court and it hasn't been paid, businesses will say, well, what are my options? How do I get my money back? Can you send someone round to take all their possessions and get my money? And it happens. I was involved in a case where the enforcement agents actually stopped a plane from taking off because that is what the company owned. It was actually an airline. So it was really, really interesting. This was in my early days of my newly qualified. Yes, I had some interesting cases. And they paid because they couldn't, their business, wouldn't be able to function without the aeroplane. So the fourth stage, once you've got the CCJ and it hasn't been paid and it's still outstanding, like I said, businesses say, well, what can I do about this? Each enforcement option has to be something that the business can actually rely on. So there are 5 main options of enforcement, but they don't always work for a business-to-business debt. A quite common enforcement option is a charging order, where we go and get a legal charge over land or property, and usually that works for individuals that own homes. Commercial enterprises generally don't own the property, they lease buildings and land, so it's not always effective. The most common enforcement method that I see and I use on a regular basis is what we call a High Court enforcement officer. So they are like private bailiffs, and they are officers of the court, and they have the power to go and attend an address of a business and ask them for payment and actually take control of goods up to the value of the debt. So if they have got cars that the company owns, or goods, just thinking of an example of a medical company that owns medical devices that I dealt a case for, then very, very expensive goods. Enforcement agents can go in, take an inventory, list all the items and say, look, we'll come back in 7 days if this isn't paid. And businesses will generally say, no, you can't take that. That's actually a customer's order. And that will make them stand up and they'll pay. It doesn't always happen. Debtors use addresses that are serviced offices. So there isn't any goods to take, so that's when you need the guidance of a debt recovery solicitor to work with the enforcement agents to try and be a bit more investigative and see if there's anything else that can be done. Actually attending a director's house is an option, but again, they have to have notice of that. They can't just go there. That's the main enforcement option. The one thing to bear in mind with enforcement options is the value of the debt. So if it's below £600 and it's a regulated debt, then the High Court enforcement agents can't enforce that debt. It has to be £600 or more. Now, the enforcement agents are very similar to county court bailiffs, although they won't like me saying that because county court bailiffs haven't got a very good reputation in terms of recovery. But if you talk to HMCTS, their statistics say otherwise. They say we've got a very good success rate with our county court bailiffs. But they do a similar job, but the first thing that the county court bailiff will do is actually, no, not the county court bailiff, sorry, the first thing that the court will do when they instruct a county court bailiff, it actually goes to a call centre now. The warrant of control goes to a call centre, they make a phone call to the debtor. If they can't get hold of the person or the business by phone, eventually it will be sent out to enforcement, a county court bailiff who will then go and visit and knock on doors and try and see if they can make contact, and so it's very similar. But the High Court enforcement officers are generally a lot more efficient because they're private companies. They are paid on a fixed fee basis according to legislation, so there is no real incentive for them not to do the work. They get fixed fees, so every single writ that's issued is done on the same fee structure. But once upon a time, actually, it was a commission-based, so they wanted to try and recover as much as possible, and they do. The other options are attachment of earnings for enforcing a CCJ, but that only works if the debtor is employed. They've got to be employed, otherwise that doesn't work. So again, for business-to-business debt, it's not really useful. So making sure you know what your enforcement options are is really, really crucial to the effectiveness of your debt recovery process. I have clients come to me when they've issued a claim form themselves through the money claims online. It's over £30,000, the judgment debt, and they're trying to enforce it by way of a warrant of control because that is the only option that the money claims online gives them, and they don't know what any other options are. And then it gets thrown back out at them, the court rejects it, and they're like, we don't know what to do. So that's why it's really, really important to work with a debt recovery professional or a solicitor to learn and understand what are our options as a business and how can we make our debt recovery process robust and effective. And actually eliminating the options that don't work for you as a business. I am going to run through the other two options because they're quite interesting. My favourite one, which isn't used a lot, is what we call a third-party debt order. And once upon a time, that used to be called a garnishee order, and it's taking control of the judgment debtor's bank account. So you serve an order on the debtor, you serve an order on the bank has to freeze the bank account, and if there are sufficient funds in that bank account, then that will get paid over to the creditor. So that's very good. So if you've got money in your bank account, it's not ideal. And I used to have clients that used to know roughly when payments were going into their customers' bank accounts. So we would try and time the third-party debt order to fit in line with when there's potentially money in the account. But the risk with that particular enforcement method is you have to know that information, and the order has to be served on the day there's money in the account. If the order is served a day after and the money's been taken out, then unfortunately it fails. So that's quite high risk. It's not very, very common. I have used it and I have been successful with it. But it is an option because people pay by bank transfer, so you can get bank details. That's all that's required is the account name and the bank details, or sometimes even just the bank name and the company's bank account name. Which one was I on? So third-party debt order, charging order, warrant of control, and a writ of control. So those are the four main options. And then there is one final option, which is not strictly enforcement, but what you can do is you can make an application. If a debtor refuses to engage with the county court judgment process and ignores the High Court enforcement agent and all the other things that you do, you can actually get an order from the court which summons the director of a company to attend court for questioning and talk about their finances. And if they don't, if they fail to engage with that and don't attend the court hearing, they are in contempt of court. They can be sent to prison. But in all my time that I've been doing this job, I've done many debtors to attend court for questioning applications. They don't turn up, they've never been sent to prison. So clients are generally quite disappointed with that. But it is an option, and it has worked. It does work. They do have to attend a court hearing and answer questions about the financial status of the company because they do move money around, and they don't like that. At each and every stage, you may get your debtors paying you. So I'm just going to go back a bit to stage one. The pre-action protocol stage, letter before action, is really, really important because debtors do pay at that stage. So you might have 5 customers and 3 may pay at that stage. So you save a lot of money rather than saying, actually, just take them all straight to court because of the court fees that are involved. They may get a claim form. And at that stage, they may pay because they don't want the CCJ and they think actually you were just saying you're going to take them to court, but not actually going to take them to court because you've never ever taken a customer to court. Now, industry to industry, word spreads. And I've got clients that say, well, what about our reputation? If we issue a claim form, what's going to happen? But I know that in the debt recovery world, for example, in my industry, it's an incestuous industry. Everyone knows everyone. And if they say, well, actually, Zakia doesn't chase her customers that don't pay her, she doesn't send them to court, so it doesn't really matter. Use her services because you don't have to pay her for it. And word does spread, so it's really, really important that when you issue your letters before action, you do follow through to the next stage if it's appropriate. At CCJ stage, once that judgment lands on somebody's doormat, or the first time they actually get notified is generally through a lender or when they've done a credit report. Sometimes they may not see the judgment that comes through their post because they just don't open their mail, but the credit report flags it up. And I had one recently where a client issued a claim, judgment debtor paid through the county court bailiff. It was £583. It was a small debt, but she paid. This was October 2023, and a week ago she's made an application to the court to say she now wants this judgment removed. But legally and technically, there isn't any reason why the judgment should be removed because she's admitted she owes a debt, she's paid the debt. But I followed up with her and said, well, sorry, we don't agree with your application. You know, you're not going to be successful in this application. And she said, but I've had a clean credit score, I've got a business to run, so it's really impacting her now. Even a year later, she's realised that actually this CCJ is affecting me. That was actually for an individual, not a business itself. But the company that I was acting for was a business. They hire vehicles to small companies. So they will pay at CCJ stage, and then if they don't pay at CCJ stage, they may pay at the enforcement stage. When businesses don't pay is generally when they are going through some sort of insolvency process, so they'll ignore every single stage. Now, insolvency is a whole topic on its own, and it is something that I cover in my Essentials of One-Day training for the debt recovery, proactive debt recovery training course. It's something that I cover for businesses because it's important for them to understand their customers and the businesses that are potentially not paying them, and they could have cash flow issues which could lead them into some sort of insolvency process, and how to protect themselves. So, my favourite bit, what can you do if you haven't got a debt recovery process? Well, I'm the answer to that. I can help you set one up. Or you can talk to a debt collection agency and work with them, an outsourced legal provider. I don't really recommend you use ChatGPT or anything because it's not quite accurate. I've tested it and tried it. It's not bad. It's a start. But you do need to speak to a debt recovery specialist if you haven't already got a debt recovery process in place. Something that I always ask my clients is to make sure their client information is kept up to date. Your contact details for your clients. If you're dealing with accounts every single day, are the email addresses correct? Has the person left? Where are the invoices going? Are they reaching the right person? A classic example, I had a client in the cosmetics industry tests the compliance of makeup and beauty products and make sure that they comply with EU regulations. And they actually had a job for Marks and Spencer's, and they were owed about £1,600. They'd been chasing, not getting anywhere. Marks and Spencer's have got quite a convoluted payment process. You've got to be a supplier, you've got to make sure you've put a purchase order in there and all sorts of things to have them set up. When I looked through her paperwork, she'd been sending the invoice because they had a criteria that the invoice had to be sent to accounts at, but she'd been sending the invoice to account at. And I'm thinking, well, surely you would have got a bounce back, but she didn't. It must have been going somewhere. And it was as simple as that. But I picked that up on the paperwork and it got paid. It got paid very, very quickly because M&S didn't want a CCJ for £1,600. So making sure your client information is up to date and accurate. Something that you might want to do is go and check, have you got any bad debtors? Have you got customers that haven't paid you? Does anybody owe you any money? Or any business owe you any money? So follow them up, pick up the phone to them. Because it's your money, you've done the work, you've delivered the service, and you should be paid for that service. Something that's really, really, really important is you reviewing your payment terms. Are they clear, and are they clear on your invoices? I've seen, especially very small businesses that don't have huge, departments that draft their T's and C's or huge budgets. Their invoices have very little information on them. But make it as easy as possible for your customers to pay you. Make sure the bank details on there. You can use Go Cardless these days. You can put QR codes in there. Give them all the different options to pay by bank transfer. Maybe not check these days, because if you do digital banking, checks are not really, they're accepted, but they're not the bank's favourite through digital banking. But make sure those payment terms are clear on your invoices. are they 30 days, 7 days? Because I see invoices and it's like, well, how does this customer know when to pay you? You haven't put it on there. So no wonder they've just put it to one side, because they're thinking, well, it's fine, we've got all the time in the world. So that's really, really important. And if you're really, really unsure about the whole process, then you can book my training, which is the Essentials to Proactive Debt Recovery, and I can help you set up a process and make sure that you have very, very few, if any, bad debtors. Because that's the aim, is to avoid businesses having to issue legal proceedings and incur the cost of legal process, because it is costly, it takes a lot of time. Even if you've got a solicitor acting for you, the solicitor will need the information from the business, because only you know your customers. So you still have to do the work, and it takes time away from you actually doing your day-to-day job. So I'm going to wrap it up there. Thank you.
That'll be cool one.